They want you to move.
And if I'm getting evicted, I want my money back.
It is my understanding that the police have been at the park.
I'm not moving out nothing. Dave is the problem.
Mr. Millerans was charged with domestic violence, resisting and obstructing. He's on probation.
But Dave don't like me. That's the only reason why they're trying to get me out of here.
That's one reason, I guess.
They're going to have fun because I ain't going nowhere.
The theme for today's video is fatal negligence. Later in the video, we have a corporation that got sued, missed the court date, then filed a set-aside motion. The owner is here without a lawyer, but with a bad attitude and an insult lobbed Judge Middleton. Then we have a guy who bought two 20-year-old jet skis for $8 grand off Craigslist, but didn't bother to see that they run. But first, we have a very contemptuous tenant who's being kicked out of the mobile home park because he keeps beating up his old lady and having police respond. I can't imagine why they want him to leave. Let's roll, nerds.
So our next matter, our 130 matter, is Golden Pond Estates versus Travis Millerans and many other occupants, which include Randy Bailey. Mr. Steve Cromendike is here for the plaintiff. I had a little trouble interpreting the pleadings, but Mr. Millerans, they want you to move and terminate your tenancy. That would give you 10 days to move out, 90 days to move or sell your mobile. They allege some violations, but I can't yet tell what they are because the pleadings aren't very clear. Mr. Cromendike, you wish to speak to that?
Yes. We're waiting on getting some police reports pursuant to a FOIA request and are still waiting on those. And we've been waiting for quite some time. So I don't have those now. It is my understanding that the police have been at the park related to Travis's behavior a number of times recently. In addition to that, I've got a couple of notes here. And Mr. Dave Elliott is present regarding some altercations with Travis and Dave, who was doing some maintenance at the park, threatening, Travis was threatening Dave. I've also got a couple of voicemails to another park manager that were fairly threatening and some complaints from neighbors as well.
Well, Mr. Millerans, that doesn't sound very good. What's your response?
Threatening me, you mean?
Are you Travis Millerans?
Yeah. Yes, sir, I am.
All right, well, they want you to move out. What do you think of that?
I'm not moving out nothing. They don't have no reason to kick me out. I didn't do nothing wrong. Dave is the problem. You are, bud.
I have been in contact with Meg as well. She just isn't present today.
We have an attorney.
She is on a bench trial right now, so she's not present today.
I spoke to Meg last
All right,
week.
well, here's what I can tell you from my files, Mr. Cromendike. Mr. Millerans was charged with domestic violence second offense in 2 file 911 SM, pled to disturbing the peace in front of Judge Patterson, and he hasn't paid the fine. The most recent case, 251627, charged with resisting and obstructing a police officer and domestic violence, August of 25. He's on probation from Judge Patterson here at the court. He isn't making his payments in that either.
His probation officer told him to pay for his anger management class and everything before he started his paying on his fines.
All right, that probably makes sense. These are just the ones from 25911 SM.
What was that second one? 25911?
SM, that was the disturbing the peace. I believe that was at the park.
It was between me and Travis.
Yes, and I believe the other one was also at the park.
Yes, between me and Travis because my nosy neighbor.
Well, apparently they don't want you to be there anymore. They'd like you to move your trailer and go away. The law says you're entitled to have a second hearing in this matter. And you allege that you have contacted Megan Bauer, which means we're probably going to have a hearing, but let's pick a day, Mr. Cromendike. Next Monday seems to be good. We're through the Thanksgiving holiday. And
Next Monday, the 8th?
Yes, 2:00. Does that work for you?
That will work. In between now and then, I will send in some of the voicemails I have and other documentation.
All right, Mr. Millerans and Miss Bailey, let me repeat. They want you to move. They want you to take your trailer out of their park and leave. And if they got what they asked for, next week I would give you 10 days from December 11th to move the trailer and 90 days, or 10 days to get out, 90 days to move or sell a mobile home. We may need to actually have a hearing on this before we get to that point. I'll pull the police reports from those other two cases that I quoted and see if they happened at the park. At any rate, do you stay in contact with legal aid? If they are going to represent you, they'll file an appearance. But we will be back here next Monday by Zoom at 2:00.
Your Honor.
I
Yes.
think Meg said she'll be gone on the 8th.
Well, if she's going to file an appearance, she knows what she needs to do.
Oh, okay.
If you're able to get copies of those police reports, is there any way that I could get a copy of them as well?
Yes, if they did happen at the park, I will email them to you.
Appreciate it.
What are these
I'll see you,
police
both
reports
next week.
about?
What?
What are these police reports about?
I don't know yet. One was the DV between you and Randy at the park.
That has
Back in
nothing to
August.
do with nothing.
Yeah, the allegations on that paper
That was against
involved him
Dave.
and Dave.
But Dave don't like me. That's the only reason why they're trying to get me out of here.
Well, oh, yeah, that's one reason, I guess.
Yeah, well, they're going to have fun because I ain't going nowhere.
Okay, well,
My trailer's too old to be moved. No trailer out
yes,
here
they
can be
generally
moved.
are. 10 days to move it,
I've
of course. So-
Been here for 11 years.
All right, well,
And I
that's
also
fun.
paid my rent today.
say that again.
They're taking my rent money?
I paid my rent today.
Well, they're not supposed to take your rent once they file a motion to terminate
Well,
your
I've been
tenancy.
paying my rent every month faithfully. I paid
That could be an issue, Mr.
$474 last night.
All right, we'll address that.
Yeah, I'll have to take a look at the ledger. It's an online payment system, Your Honor, so I don't
Yeah.
see.
And if I'm getting evicted, I want my money back.
Why? You're still there. You're paying for rent for time that you're actually there, not future rent. Anyway, we'll address this further.
Okay.
next Monday.
What do you mean why? Because if I have to move, where I need that money. That's why.
Yes. Okay. Well,
Like,
you're
I'm not
living
trying to
there.
be.
You just paid November to December's rent. Well, we'll address it next week. It'll give me
Okay.
something to look forward to. Thank you.
Almost $800. I need that.
Okay. I believe you. Now we got a bunch of people in the waiting room. Next, we have Hometown Welcome Program versus the Waxahachie Sun. Mr. Andrew Rognus is here on behalf of Hometown Welcome and Dan Tollefson. I assume Scott is here on behalf of the Waxahachie Sun. This was a substantial judgment, $10,057.38. Hometown Welcome was represented by Mr. Rognus. Waxahachie Sun was not represented. They are located in Waxahachie, Texas. This is not a small claims case. It's a general civil case. And Mr. Scott Brooks is representing the Waxahachie Sun. And I don't believe he's an attorney.
No, I'm not.
But anyway, they filed this action. You filed an answer. They filed a motion for summary disposition and a hearing, and you didn't show up. So on October 13th, I issued a judgment in behalf of the plaintiff for $10,367.38. Mr. Rognus has done a pretty good brief in this matter, setting forth what the standard is to move to set aside a default. One, you have to have a good reason for not appearing, and then you have to have an affidavit of meritorious defense. Mr. Rognus, what's your position here?
Well, Your Honor, I think as we indicated in our brief, you cannot appear without counsel unless you're an individual representing yourself. And in this particular circumstance, no brief, no affidavit, no good cause, and no basis for the motion to set aside the default. Pick any one of those reasons.
Mr. Brooks, what's your position at the Waxahachie Sun?
Well, we responded to what we have received. I'm not an attorney, and I own my company, and so I'm representing myself and the company.
You can do that. Is it
Okay.
a corporation?
Excuse me?
Is it
Is
a
it a
corporation?
Yeah, it's an LLC.
Well, then you can't represent it. you can't treat it as a independent business for one purpose. Someone sues you and they say, wait a minute, it's a limited liability corporation. I'm only limited to the assets of the corporation, not my personal assets, and then show up to represent an LLC. I'm not sure exactly what the law is in Texas, but in Michigan, an individual can't represent an LLC or a corporation. So that's one problem. You're not an attorney. Secondly, you have I don't know whether there's a meritorious defense, but you did show up for the hearing, and in your letter, you say, it's my fault. Accept my apologies. The reason is entirely my fault. That's not a good reason for setting aside the default that you forgot to come that day. So there, as Mr. Rognes said, there's multiple problems. One, you can't represent the Waxahachie son. Two, you haven't stated a good reason for failure to appear. Three, there's no affidavit of meritorious defense. You sent a letter which explains some things, but it's not the same as an affidavit, which is a sworn document. So probably in hindsight, you should have taken this to an attorney as soon as you got it. But I'm declining to set aside the default.
What is the letter that I received saying the court has accepted your motion to set aside default judgment?
I set aside the motion to set it for a hearing, which I just did. That doesn't mean you win.
Well, I'm not necessarily looking to win. I'm looking for a judge to hear what's fair. I don't know what the laws are in Texas as it relates to an attorney. I don't have money to be spending on an attorney for something that I don't think we in any way owe. And all I was wanting was a chance to be able to explain that and let a fair jurist hear it. That's all.
Well, that's a legitimate desire. This ain't small claims court. You got sued in general civil court. The Michigan rules of civil procedure apply, and there's not special exceptions for lay people. I do grant much consideration to lay people, and I would grant more consideration if this was small claims. But you're in the weeds and you're in over your head. You got sued for $10,000. Your company did. You own the company, but it's a limited liability corporation. So you don't have the right to represent it. It's a separate entity. And so you may wish to have had a jurist hear this. And I've had a number of these cases over the years with small town, local, out of county newspapers, and they're interesting. And I'm sure the Waxahachie Sun is an interesting thing. But don't put it on me.
I'm not putting it on you, Judge.
You did
I'm not.
the rules.
I'm not putting it on you. I'm not putting it on you. I'm not.
Right.
I'm sorry if I did that. That isn't my intent. My intent is to pursue whatever I need to do.
Sound like an insult, like you're not a fair jurist and you're not willing to hear my case. I would have been if you follow the rules.
Okay.
Anyway,
right.
The motion to set aside the default is denied.
Okay.
For the reasons stated on the record. Mr. Rognes, do you wish to, Mr. Tollefson wish to speak to Mr. Brooks?
I don't think so, Your Honor.
All right. Mr. Brooks, they'll be in contact about attempting to collect on this.
And they will collect it. See ya.
Yes, I'm sure that won't be easy.
No, it won't.
Seize your printing press or something. All right, you're good to go.
Shame on you, Dan.
All right, motion is denied. I've signed an order, Andrew.
Okay, but we already have a judgment, so I don't think we need anything additional.
No, you don't need anything else. Collecting on this judgment may be interesting, but the original judgment stands.
Okay, thank you.
Mr. Tollefson, best to you, sir.
Thank you, Judge.
Mr. Hawker, do you understand that once we begin, any decision here is final?
Yes, sir.
Mr. Banks, you understand?
Yes, I got a request of the court, Your Honor.
Yes, sir.
I'd like to request that the court dismiss the case against me based on the court lacking personal jurisdiction, as I do not reside in St. Joe County, and the court lacking subject matter jurisdiction, as the claim did not arise or any action or occurrence that happened in St. Joe County.
Well, Mr. Hawker lives in St. Joe County, and I have jurisdiction over you because you're here. He's claiming the statutory maximum, $7,000. He claimed he purchased a pair of jet skis from you, advertised as working units. The engines are bad. He spent $8,200 on these jet skis. Now, normally buying something used without a warranty has got issues with it. But anyway, your motion to deny for lack of jurisdiction is denied. A, you're here. B, he lives here and he bought these here.
No, Your Honor, he bought them in Calhoun County.
All right, but he lives here. He lives in Sturgis. Mr. Hawker, why do you believe he owes you $7,000?
When I purchased the jet skis, he said that they were good units. They run, although he purchased them a year and a half prior to my purchasing them from him. He did not use them, but he still said that he would still stand behind them. So I brought them home. I put oil in them, and the one unit would not even start. So I took the unit to the dealership in Kalamazoo, Ziegler Power Motorsports. They tested the unit that would not start and said that the compression was bad on all 4 cylinders. And they could not repair it due to not being able to get parts. It was such an old unit. The second unit I brought home. I could at least get it started, but I put it in the water for a test run. It blew out smoke, and then the engine seized up, and neither units are functioning. And the maximum damage allowable would be the $7,000. So that's what I am asking for.
All right. Let's see what we got here. How did you find these? Craigslist?
Yes, sir.
You understand how foolish this is? Gee whiz. 2028 Yamahas. They're almost 20 years old. There's no warranty from the company. Did he provide any warranty?
He said that they were good units and he would stand behind them. He would not sell them.
To a level of warranty. Mr. Banks, what's your position?
Yeah, I purchased them, like I said, a year and a half ago. I never used jet skis. I invested $1,500 to $1,800 that in equipment, new vests, new batteries, ropes, fire extinguishers. Due to an injury to my shoulders, I wasn't able to use them. I purchased them as is. Like I said, never did anything, never had them in the water. And due to the fact that he had opportunity to grab them and test them before purchase, like other people had contacted me and asked they would have to start them up and do a sea trial or whatever they needed to do to purchase them. He had that opportunity to do as well, but he chose not to, and he bought them as is. Like I said, I did give him all that stuff for free. I am well over 11,000 in new stuff that I added that I just gave to him with the jet skis. New tires, new fenders. I gave him the old tires as well.
So this
tires.
included a trailer, a dual trailer, and all of that?
Yes, plus the extras that I bought and purchased to ride them, but I never got to. So I'm 12 grand. I gave him over about 12 grand worth of stuff in the deal.
You're both very foolish. You're selling something and saying it's operational. You never even put it in the water yourself. You're either fraudulent or willfully ignorant of whether these would run or not. They sat for some period of time without running through the winter. Don't know whether they're winterized properly. Don't know whether they were sealed. Mr. Hawker, you're even more foolish. You see a Craigslist ad, you give a guy $8,200 for something and never bother to see whether it'll run or not. You also are now the owner of a trailer. He's not a dealer. He didn't provide a warranty. And so I'm not sure who's more foolish than the other. He sold them for $8,200. The trailer How much is the trailer worth?
$4,000 alone.
That's hard to discern what a used trailer is. It looks like a nice trailer. The way this works, he gets to keep the stuff and you owe him $7,000. So he sued you in small claims court. He's not saying, I want you to take the stuff back. I just want $7,000 for a functionally functional dual trailer and 2 wave runners that I never bothered to test. That seems unfair. He keeps the stuff, including the trailer, and you pay him $7,000. That's a pretty good deal for him, not such a good deal for you. The other side of the coin is he gets nothing. You sold him this stuff without a warranty. I'll stand behind him. I wouldn't exactly say it amounts to a warranty. You're not a dealer, and he never tested them. And he gets to keep the trailer, which I'm not sure how much it's worth. I owned a wave runner trailer at one time, a long time ago, and it was steel, not aluminum. So, Mr. Hawker, what's your last word here?
I will accept the court's decision.
All right, I don't like it really when you step back and look at it. I've said he's selling you this stuff that he doesn't even know whether it works or not. Expensive motorized equipment. He never bothered to start it, although neither did you. He made improvements to it, put new tires, fenders, other ancillary equipment like jackets and that sort of stuff, selling you, saying, hey, I guess it works. In small claims court, the same standard of proof applies as to regular court. The burden of proof is on the plaintiff, and they have to prove the case beyond a preponderance. There was culpability on each side, on the seller's side for not knowing whether the thing even worked, on the buyer's side for not first confirming that 2 expensive pieces of water equipment that are almost 20 years old worked. I find a tie, in which case the tie goes to the defendant. Plaintiff has to prove the case beyond 50%. Mr. Hawker does have these devices, which apparently have some value, and he also has the trailer, which may have some value to recoup against his $7,000. But allow him to keep both units and the trailer and $7,000 just is too unfair. The defendant was a private seller. He was not a dealer, and there was no express warranty. So I find for the defendant, the damages are 0. Mr. Hawker, perhaps you can sell some of this stuff and recoup some of your investment, but I find for the defendant. All right. Thank you both.
Thank you, Your Honor.